Call this meeting of the Plan Commission to order. Madam Secretary, if we could have a roll call whenever you're ready.
Mr. Ackerson?
Here.
Ms. Billman? Here. Mr. Fell?
Here.
Mr. Fitch?
Here.
Mr. Hopkins?
Here.
Mr. Storr? Mr. Trail? And Mr. Turner?
We have a quorum, just barely. Are there any changes to the agenda? Approval of minutes of the June 8th, 2017 regular Plan Commission meeting.
I move they be accepted.
Motion by Mr. Ackerson. Second by Mr. Fell. I do have one change to the minutes that I showed to Ms. Pearson. It is on page 10. I read that far. In the second to last paragraph on that page, there's a sentence that says, Ms. Billman asked about the purpose of the proposed text amendment, and we weren't discussing a text amendment at that time. It was this presentation of the staff survey. So instead of proposed text amendment, it probably should say the purpose of the parking study or some such. That's it. Otherwise clean. Do we have, we're going to have any other comments on the minutes? All right, we'll have a voice vote. All those in favor of approving the minutes with the change, say aye.
Aye.
Those opposed? The minutes are approved as amended. We have no communications, no continued public hearings or old business. We have new public hearings. We have Plan Case 2307 M17 and 2017 A02, a proposed annexation agreement between the City of Urbana and David Borchers, including rezoning of property from County AG2 to City Industrial for an 11.47 parcel located at Smith Road and Coachman Drive and north of Coachman Drive at 801 North Smith Road in Champaign County. This is apparently not quite ready for it to be heard, but the hearing is opened and is continued to the July 20th, 2017 Plan Commission meeting. We have new business. Excuse me, Mr. Ackerson.
Is it here because we would need to be able to see it? What I'm wondering is being continued, I understand, but does it need to be presented this time so it can be voted on the next? Or?
It has to do with the notice requirements.
Okay. That's what I wanted to know.
Yeah, exactly. We have a new business case, CCZBA 873AT17, request by the Champaign County Zoning Administrator to amend Section 7.1.1, 7.1.2 of the County Zoning Ordinance regarding home occupation. Mr. Marks.
Good evening. As stated earlier, this is for a case concerning the city's potential protest rights for a text amendment to the Champaign County zoning ordinance. Champaign County has previously not permitted auto repairs as a home occupation in their zoning ordinance. They have proposed a text amendment which would allow auto repair to be an approved home occupation as an accessory use if with a special use permit for residential properties that are located within 1.5 miles of or within the extraterritorial jurisdiction of a municipality that specifically allows such activities. As you're probably aware, the ETJ stands for extraterritorial jurisdiction, which is the 1.5 mile radius outside of an incorporated community in which the city has certain rights, such as the subdivision rules and protest rights for different changes to count certain county policies. So the county has drafted this, has proposed to allow this use and it is designed to permit it in the vicinity of communities that do allow this, not communities that do not allow it or are ambiguous in their zoning ordinance in which such an activity is permitted or not. The city of Urbana specifically does allow home auto repair in its in our zoning ordinance. The city's zoning ordinance specifies that such is allowed with a Type C home occupation permit. That is a category that is of the highest intensity of use and is required to be granted a conditional use permit by the city's zoning board of appeals. The proposal by Champaign County would allow the activity to be permitted, auto repair as a home occupation, with a special use permit as approved by their by the Champaign County Zoning Board of Appeals. I'm just going to briefly go to a map of the ETJ for the city. You'll see that the orange encircled area is the city limits of the city of Urbana. The sort of that lavender purple color to the left is the city limits for the city of Champaign. I'm not sure how well it's coming up on the monitor, but you will see the ETJ for the city of Urbana towards the east, sort of surrounding the eastern half of the city and most of the southern part of the city. That is those are the neighborhoods and areas in which this this text amendment would be applying to. If the area, even if it overlaps within the city of Urbana, if it overlaps with the city of Champaign, it would not be permitted. The city of Champaign does not specifically allow auto repair as a home occupation within their zoning ordinance. So the county's proposal would only allow this for the city of Urbana's ETJ that does not overlap with the city of Champaign's. Within the text amendment changes you'll see in the attached exhibit of the packet, within those proposed rule changes are also some of the rules designed to keep the use from not disrupting the surrounding neighborhood. That includes language specifically stating that the use must preserve the property as a principal use or preserve the residential use as being the principal use. The home occupation still must remain an accessory use to the use of the household as a dwelling. It also includes limits on hours of operation, limits on the numbers of vehicles, the locations of where vehicles may be stored, no unregistered or inoperable vehicles, limits in the amount of space that can be devoted to the home occupation. It's also important to note that this does not permit what is considered major and or minor home automobile repairs. Or I should state, major repairs are ones that are more intensive changes to the car, such as body work, changes on the frame, painting, major engine work, etc. There are significant building safety code requirements that must be taken into account for performing those operations on a car, many of which would be difficult to accommodate in a residential home. The city of Urbana does not permit those sorts of changes, so the county would not permit them either as a home occupation. So the results for, I guess looking at the rules that they're proposing, they're pretty congruent to what the city requires in terms of a vetting process and the sort of public hearing and approval that's needed for the use, as well as the rules designed to permit the use while protecting the surrounding neighbors. So, you know, this text amendment will affect some areas that are rather close to the city. The Champaign County memo actually makes reference to that it is one or two specific homeowners that are close to the city of Urbana that are requesting, you know, this permission to be allowed. The county has been very good about, you know, corresponding with the city to make sure that these are rules that would be consistent with the city's policy and the city's intentions for areas that are very close to Urbana neighborhoods or might someday become part of Urbana because of their being in the ETJ. So, with that said, just briefly a review of the city's ability to contest a text amendment. The city will exercise. I shouldn't say exercise. The city will prepare for any text amendment or rezoning or anything in the city's ETJ that it would have challenge rights over. The city, as standard, will prepare a potential resolution of protest should the city decide that it is opposed to an action taken by the county. This has not happened very often, but we've done this every time for any potential protest should the city want to enact one. If the Plan Commission recommended a resolution of protest that the City Council therefore approved, what it would change is it would require a 2/3 vote of approval by the Champaign County Board. So that's what mainly a challenge would accomplish. So the city does prepare itself with every measure to adopt a resolution in potential, but rarely has the city council voted to enact an official protest. It's mainly a mechanism that allows the city to be prepared for changes in county policy. So the three options that you may have, you can recommend to, so the proposal is to draft a resolution of protest. You may recommend to defeat that resolution of protest if you find that this is a worthwhile text amendment by the city. You may recommend to defeat a resolution of protest contingent upon certain or on some specific revisions, or you may recommend to adopt a resolution of protest if you find that this text amendment is problematic for the city. So do you have any questions?
Any questions for Mr. Marks?
Oh, my apologies. The staff recommendation is to defeat a resolution of protest.
Mr. Hopkins?
I admit I read this a couple days ago, so I don't remember. The only municipality to which this is going to apply at the moment is Urbana. Am I correct? It doesn't apply to Champaign, but it also doesn't apply to Savoy or Rantoul, or do we know?
There are several municipalities in the county that are somewhat vague about whether they specifically allow it or not. Urbana, I'm not familiar if Urbana is the only one, but we're one of the few that specifically state if this is allowed or not allowed, and we do state that it is allowed. So this might affect others, but I would have to do a closer look.
Any further questions? I've got a number of questions. So, thanks for the other cities. I had that one on my list. I wanted to talk about, if I understand correctly, this would require a special use permit in the county, but a conditional use permit in the city of Urbana?
This does not affect.
So Urbana, our zoning board of appeals would not weigh in if a situation should occur and a county special use permit would be approved?
No, the city's process would still remain in effect for properties within city limits.
But not in the ETJ?
No, it would add, no.
I think Chris's point was just to show that it's a similar process in the county as proposed to what we do.
Right, but I just wondered if you were going to have kind of a dual approval process with slightly different mechanisms of achieving the end. The other thing, and this is going to get, I guess, pretty technical, but I was looking in the table of uses and trying to figure out where this could happen if a property were annexed into the city. I realize if it's just an ETJ, you know, but
You wouldn't find it in the table of uses because it's designed in the city's zoning ordinance to still be a accessory use, and that the
Okay.
principal use would still be the residential nature of the household.
okay, that's good, because we almost don't allow this anywhere as a primary use. So that's one thing. What would happen if, well, I guess if it's an accessory use, then my next question's moot, because I was going to ask what happens if one of these properties gets annexed into a district that won't allow it. But, you know, I suppose if it's an accessory use, then that answers that question. I think that I want to ask about the specifics of the text amendment versus Urbana's ordinance, and see if I'm reading this right. The only place I could find, there's the definition of major and minor that you went over in our ordinance. But the only place I could find in the use regulations speaks to home occupation involving vehicle repair shall be permitted only if the vehicles are inside the garage and no inoperable vehicles outside. Vehicle may not, waiting to be repaired may not queue outside of the garage. Additionally, the garage must meet codes and so forth. Seems like the county's ordinance is broader than that.
The county's ordinance, I think, is more specific about certain restrictions than even ours
You can
goes
have
by.
like 2 vehicles outside or some such. They can't be parked on the ground. I was really worried about the vehicles sitting outside waiting to be worked on, which our ordinance pretty clearly, I don't think, would allow. Am I reading that right?
One moment, let me just.
Yeah, I was looking at, in our ordinance, at V12E
Yes, in
of ours, and there's a number of different conditions, but it talks, no more than one inoperable vehicle may be parked outdoors at the property. No more than 2 resident vehicles and 2 customer vehicles may be parked outdoors at any time. You know, things of that nature that our ordinance wouldn't allow, if I'm reading it right. Which, you know, not sure I feel about that.
I apologize. Would you be able to summarize your question once
Oh,
again?
my question is, am I reading their ordinance, proposed ordinance correctly in relation to ours, that theirs is more permissive into the types of parked vehicles and where they have to be located, where they can be located? In other words, we had one of these in our neighborhood. I tell you where I'm coming from. Maybe this will wait for discussion. And there was a lot of vehicles. And eventually the city figured it out and shut them down. There used to be one on East Main. And I don't know if it's I didn't read the whole county memo, and I don't know if it's one of those residents or not. There used to be one on East Main right before the main spur in an unincorporated area near the city. And there used to be a lot of vehicles parked out there. Now, if they're passing this ordinance now, I don't even know how the person was doing it, but there was an actual sign out there that said something auto repair, so-and-so's auto repair. I went looking for it today, and the sign's not there. So I don't know if, do you know anything about that?
Well, that's probably a separate enforcement case that preceded my tenure at the city. In regards to your question about whether the county is more permissive, I think you could say that in terms of the we do have a limit of commercial vehicles that are associated with a home occupation use, but their ordinance says no more than 2 resident vehicles and 2 customer vehicles, and our ordinance just specifically mentions no storage of vehicles on the outside. and that they may not queue outside the garage. So I do believe that is correct.
Yeah. Okay, I think that's all I've got on that one. Let's see if I've got anything else. No, I think, one thing, you said a two-thirds, I want to just review for the commissioners, most of you may know, but the options and the consequences. I think that, as you mentioned, we can say support or defeat a resolution of protest. We can say defeat a resolution of protest with a contingency. And then we can say adopt a resolution of protest, which according to the memo requires a 3/4 majority of the county board. I don't know if it's 2/3 or 3/4 in actuality, but in any case, it requires a supermajority. If we were to say option number 2, defeat a resolution of protest with a contingency, that doesn't trigger the supermajority, correct?
No, what we generally do, and the county staff is always really amenable to comments. So we would say, hey, if you change some things up, then we could
We
probably
feel
get
better
it.
about it.
Yeah.
Okay.
May I make a comment as well?
Sure.
I realized I did not comment on the timeline that the county was considering for
Oh,
this.
great.
Their ZBA is set to look at this again on August 17th. The ELUC would look at it on September 7th with a potential adoption by the full county board on October 15th. So,
Okay, so there's a little time.
yeah.
Yeah. Okay. Any further questions? Thank you, Mr. Marks. All right. I guess there's no public participation on this tonight, so we'll go straight into discussion. Any discussion or comments or motions?
Since we're running fast, I find it intriguing that if I choose to get a permit in the county for this, I can no longer park my third car on my property.
That's interesting. It is. I hadn't noticed that one.
If I were in the county, I mean, if I cared, I
Yeah.
would say that needs to be fixed. Because the number of people who,
Have 3 cars, yeah.
well, especially if you live in the county, one of the reasons people live there is because they've got an extra hobby or they
Or you got a teenager.
commute
Yeah.
or you got a, it just seems oddly worded.
Perhaps what they're getting at is that if you choose to have this kind of home occupation in order to keep your site from having too many cars on it, that you would need to make a decision on whether or not you have residential cars
I
or
mean, and
customer
I
cars.
mean, I could see the sort of logic of it. I just find it kind of intriguing.
Mhm.
But I don't want to go anywhere.
Well, you heard my questions and, where I was coming from. I'd like to see them bring their specific requirements into alignment with our zoning ordinance. I would pull up short, approve a resolution of protest, that's pretty, it's never happened since I've been here. It's pretty drastic.
May I have a little clarification? Because I thought that we tried to illustrate that it's actually stricter than ours. So are you suggesting that it should be less strict than ours?
No, I think the way I read it is that it's more specific but less strict.
Okay, is there specific?
It was literally having 2 inoperable or vehicles in the queue to be repaired sitting outside of the house, and in which ours appears to me to say that any vehicle to be repaired may not queue outside of the garage. And in a couple of the cases I'm familiar with, this place over on East Main and then the one that was right, you could almost see it from the city building, there were usually 2 or 3 cars on blocks or, waiting to be repaired. And to me, that's where the nuisance aspect starts to come into it. So I'm not sure where I'm going with this, except to say that I personally would be more comfortable if I'm reading it correctly, first of all, and then second of all, if it were more in line with no vehicles can queue outside the garage. Sure. Well, any discussion on the discussion?
I'm mulling it over. I'm thinking, I looked at the map because I was trying to think of, when I think county, I'm thinking larger spaces and things like that where that may not be as much of an issue. But when I look at the map, there are in fact subdivisions that look a lot like subdivisions inside the city that would be affected by this. I'm not sure if I can tell a lot of difference other than you're saying there could be one or two additional cars queuing outside, so you could be taking up.
Yeah, and again, it's, the one I was thinking of, it's pretty separated from the other neighbors, but you're going down East Main and all of a sudden you're in the unincorporated. So would it really be a problem? Here it was a problem because it was, right back behind the building. But that was, a different situation maybe. Mr. Hopkins?
So I'm trying to think this one through. This, from the county's point of view, this is only permissible within the 1.5 miles. It's not permissible outside the 1.5 miles in the county. Am I correct?
I think.
I think that's what I heard you say. That sounds a little
The-
odd to me, but
The county has a distinction of neighborhood versus rural home occupations, and I believe it is allowed outside of. I believe it would still be allowed outside of the ETJ within the 1.5 miles. Outside, if it's not in any municipality's ETJ, it would still be allowed depending on the type of, if it's a rural versus a home occupation, or if it is a rural home occupation versus a neighborhood home occupation.
and how do they define the distinction between a neighborhood area and a rural area?
I think it states those two uses are defined specifically in the Champaign County zoning ordinance.
I can read them for you if you like. Let me turn back to neighborhood. So neighborhood home occupations are permitted as and I'm taking out some references here, are permitted as an accessory use subject to the following standards, which are numerous and which then go into the minor auto repair. The rural one gives a little more information. Rural home occupations are permitted as an accessory use in any dwelling in the AG1, agriculture, AG2, agriculture, and CR, conservation recreation districts. And there's also a number of standards. So it's more of the agricultural zoning.
Okay.
Would
So,
they be-
so the neighborhoods that we would be concerned about, that when you look at the edge map, are not, and I should be asking rather than stating, but I'm
Yeah.
pretty sure, are not zoned Ag 1 or Ag 2. They're county zoning, residential, whatever.
You said the subdivisions right outside of Urbana, correct. They would be a residential zoning in the county.
Okay, so, and I'm now hearing that this county text amendment does not apply to rurally zoned areas. It only applies to non-rurally zoned areas, and it only applies if it's within the 1.5 miles of a city that would allow it.
Before this text amendment, it was permitted as an accessory use for rural home occupations, or it was permitted as an accessory use. It was always prohibited for neighborhood home occupations, and this text amendment would change that to.
Okay, but the way neighborhood gets defined is by zoning use, by use
Yes.
designation. Am I correct? That's what I think I'm hearing.
I believe it is. Lori's checking the Champaign County zoning ordinance at the moment.
Okay,
or-
so if that's true, then I'm inclined to support Tyler's proposal that this text amendment ought to match more closely our more restrictive queuing, because that does not affect the rural zoned areas where somebody who's living on 10 acres, it's not really
Wouldn't be
a
a problem,
problem if
exactly,
they've got
right,
3 cars
right.
lined up. They probably already have 3 cars lined up that they're not using at the moment, in addition to the truck and 2 cars they've got.
Mhm.
So that would suggest we try to word a contingent no protest.
Yeah, and so that went to my question, do we want to go down a contingency, or kind of let our concerns speak for us?
Well, they've got till,
Yeah,
they've got 3
knowing they have
sequences of
time, yeah.
meetings they're going to have.
Yeah.
So it seems to me if we make a conditional, a recommendation
yeah.
for a conditional defeat of a protest, and that the condition is that their conditions for
Parking cars outside.
outside, whatever ours, be at least as strict as Urbana's. And it shouldn't be a problem because it doesn't apply to Ag 1 and Ag 2 and so forth, which is what I was worried about
Additional point of
before.
clarification, yeah,
Yeah.
great. Well,
So well, I can make that motion because you can't.
right, right.
Then we can see if we can get a second.
Okay. Please proceed. You got,
No, what I meant
Oh.
is, well, I wasn't trying to take the chair, I was going to.
oh, no,
But if you want to make the motion, that's fine.
no, go ahead.
So
It's all you.
I would move that we recommend a defeat of, a recommendation of protest with the condition that they modify their conditions for a special use permit to be the same as Urbana's restrictions for a conditional use permit
In regard to parking cars outside?
in regard to parking cars outside. And there aren't any other differences that we know of, are there?
I don't know, it looks, ours is really vague and theirs is really specific, so there's a lot of differences
Yeah,
in that
okay,
sense.
no,
Yeah,
that's fine,
right.
okay.
Motion by Mr. Hopkins. Do we have a second? Seconded by Mr. Fell. Any further discussion?
No, I just,
Mr. X?
I like the fact that we're limiting it to just the discussion of the cars and not telling them
broader.
it has
Yeah.
to be
Sure.
exactly, yeah.
Okay.
All right, hearing no further discussion, we'll have a roll call.
Mr. Fell?
Yes.
Mr. Fitch?
Yes.
Mr. Hopkins?
Yes,
Mr. Ackerson?
Yes,
And Ms. Billman?
That motion is approved, and I guess it'll go to the city council. Has there been a date set yet for that, or contingent maybe upon?
In light of the new
Yeah.
condition, we'll probably want to talk to the county staff
Sure.
and get them on board first.
Makes perfect sense. Thank you. All right. We have no audience participation tonight. Do we have a staff report? No study session. Therefore, we are adjourned.